The Constitution delegates to Congress the power to regulate commerce among the several states. What makes commerce not just commerce, but interstate? That's part of the question the Supreme Court was asked to answer in the case Flowers versus Brock, which we'll look at next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach our generation be free. Glad you could join me today. This question of interstate commerce is a big one because, well, Congress has used and abused it quite a bit. I want to get into the article, into the episode with all the details. If you'd like to follow along, head to the website, constitutionstudy.com. Find this article. You'll find links to all my sources. Now, I'll also talk more about the website and other things you can do there at the end of the episode. But for now, let's get into this case about the Commerce Clause. The Commerce Clause of the Constitution is pretty straightforward. Congress has the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. The problem is people don't always agree with what commerce among the several states, and otherwise known as interstate commerce, actually is. Black's Law Dictionary defines commerce as intercourse by way of trade and traffic between different peoples or states and the citizens or inhabitants thereof. Seems pretty simple to me. Commerce is trade between peoples within a state or citizens of other states. There's a bit more to it, though, including but not only the purchases, sale, and exchange of commodities, but also instrumentalities and agencies by which it is promoted, and the means and appliances by which it is carried, and the transportation of persons as well as of goods, both by land and by sea. So commerce is not just the sale of goods, but the means by which the sale takes place. Well, that may seem simple to us. Attorneys and judges have a way of making simple things complicated. Take the 1942 case Wickard versus Filburn. The appellee for many years past has owned and operated a small farm in Monterey County, Ohio, maintaining a herd of dairy cattle, selling milk, raising poultry, and selling poultry and eggs. It has been his practice to raise a small acreage of winter wheat sown in the fall and harvested in the following July, to sell a portion of the crop to feed part of the poultry and livestock on the farm, some of which is sold, to use some in the making of flour for home consumption, and to keep the rest for the following seeding. The intended disposition of the crop here involved has not been expressly stated. Here we have Mr. Wickard, a small Ohio farmer selling milk, poultry, and eggs. He also raised some wheat both to feed himself and his family and to sell a portion of it. Seems like no big deal. Except this is 1942. Not only has the country just joined World War II, but is in the middle of FDR's unconstitutional attempt to regulate the economy from D.C., which means the federal government gave Mr. Wickard a quota for the amount of wheat he was allowed to grow. In July of 1940, pursuant to the Agricultural Adjustment Act of 1938, as then amended, there were established for the appellee's 1941 crop a wheat acreage allotment of 11.1 acres and a nominal yield of 20.1 bushels of wheat an acre. He was given notice of such allotment in July 1940, before the fall planting of his 1941 crop of wheat, and again in July of 1941 before it was harvested. Now, put aside for the moment the violation of the Fifth Amendment's Due Process Clause. Ignore the Marxist idea of government regulation of the economy. Forget that this was the exact form of government overreach that led the colonies to declare independence from an overbearing government. It appears Mr. Wickard did not ignore the Constitution, but decided to exercise his liberty, protected by the Fifth Amendment, and did just what he wanted. He sowed, however, 23 acres and harvested from his 11.9 acres of excess acreage 239 bushels, which, under the terms of the Act as amended in May 26, 1941, constituted farm marketing excess subject to a penalty of 49 cents a bushel or $117.11 in all. The appellee has not paid the penalty and has not postponed or avoided it by storing the excess under regulations of the Secretary of Agriculture or by delivering it up to the Secretary. The committee therefore refused him a marketing card which was, under the terms of the regulation promulgated by the Secretary, necessary to protect a buyer from liability to the penalty and upon its protecting lien. Imagine that in America, needing permission from a bureaucrat to grow your own food without being penalized. This led to the lawsuit, which eventually made it to the Supreme Court, which found the power to regulate interstate commerce includes the power to regulate the price at which commodities in that commerce are dealt in and practicing affecting such prices. An argument can be made that the power to regulate includes the power to set prices, but not control production, especially production that does not go through interstate commerce. A factor of such volume and variability as wheat grown for home consumption would have a substantial influence on price conditions on the wheat market, both because such wheat, with rising prices, may flow into the market and check price increases, and because though never marketed, it supplies the need of a grower which would otherwise be satisfied by purchases in the open market. This is another example of the Supreme Court just making things up, in general to support the made-up powers of the very government they're a part of. This lie by the court that Congress can regulate anything that might impact interstate commerce has been the basis of the federal government's attempt to regulate every part of our lives. So just when does commerce become interstate commerce? More importantly, when can the federal government meddle in a person's commerce? The Federal Arbitration Act, FAA, requires courts to enforce many private arbitration agreements, but it also provides that nothing in the law shall be used to compel arbitration in disputes involving contracts of employees of any class of workers engaged in interstate commerce. That's Title IX U.S.C. Section 1. This case poses the question of whether someone can qualify as a worker under Section 1 exemption if he never crosses state lines and never interacts with vehicles that do. Many employment contracts include an arbitration clause, which requires most issues between employers and employee be settled by binding arbitration rather than a lawsuit. Congress told the courts of the Federal Arbitration Act that it must enforce those arbitration clauses. Article 9, Section 1 defines for the purposes of this law what interstate commerce is. Now, Angela Brock held a franchise that transports goods produced by Flowers Foods, Inc. in the Denver area. In 2022, Brock sued Flowers in federal district court, alleging that the company had underpaid him and other distributors in violation of various federal and state laws. Flowers moved to compel arbitration, arguing that the FAA generally requires courts to stay or dismiss cases when the parties have agreed to resolve their disputes by arbitration, and that Brock had signed a distribution agreement promising to arbitrate any disagreement. The district court denied Flowers' motion, and the 10th Circuit affirmed. Resting its decision in Title IX, Section 1, the 10th Circuit reasoned that Brock belonged to a class of workers engaged in interstate commerce, and thus the court lacked authority to compel arbitration. Now, Mr. Brock only transported goods within the state of Colorado, so how does this qualify as interstate commerce? The statutory text does not support a rule requiring workers to cross state lines or interact with vehicles that do. When the FAA was enacted, to engage meant to take part in something or to be employed or involved in that thing. And interstate commerce meant traffic, intercourse, or the transportation of persons or property between or among the several states, or from between points in one state and points in another state. Nothing in those terms requires an individual to cross state lines or interact with a vehicle that does. Okay, according to SCOTUS, Mr. Brock did take part in interstate commerce, even though his portion was solely within a state. And in this case, Mr. Brock was part of a transportation chain that included interstate transportation, i.e., interstate commerce. Remember, this case isn't specifically about interstate commerce, but whether or not Mr. Brock is part of a group exempt from the arbitration requirements of the Federal Arbitration Act. Held, a worker who transports goods on an intrastate leg of an interstate journey can qualify for Section 1's exemption without crossing state lines or interacting with vehicles that do. For me, the issue is not the question of arbitration, but of the definition of interstate commerce. Congress has used the decision in Wickard v. Filburn, which helped twist the idea of interstate commerce over 80 years ago, not only to implement their unconstitutional power grab, but a literal reign of terror over the American people. Just look at the laws used to regulate car fuel efficiency, what appliances you can use in your home, even the food and pharmaceuticals, and all this based on a claim that Congress has the power to regulate because it could impact interstate commerce. Based on that, I fully expected this to be another dumpster fire courtesy of SCOTUS. Now, I argue that Congress had no legal authority to pass the Federal Arbitration Act because the Constitution does not delegate to the United States the power to regulate contracts or employment. That said, the Supreme Court actually made a reasonable argument about whether or not Mr. Brock actually participated in interstate commerce. Now, if only the same court could recognize that the FAA is itself unconstitutional, null and void, then we'd have a decision truly worth praising. I know. The case was about the Federal Arbitration Act, but that question of interstate commerce really piqued my attention. It was something worth looking at, which to me begs the question. If interstate commerce means you must actually be engaged at somewhere along the way in interstate commerce, well, how many of these laws that say, well, we can regulate this because it might pass through interstate commerce, suddenly become, you're no longer regulating interstate commerce, you're regulating all of our lives. This Filburn decision has been abused by Congress for decades to take over our lives. Well, this might pass through interstate commerce. This could pass through interstate commerce. This may have an impact on interstate commerce. Congress is only allowed to regulate interstate commerce. So the question is, okay, if you're not actually involved in commerce across the state, either directly or as part of a transportation leg, well, then how is it part of interstate commerce? It's a question. It's a serious question because you think of what Congress does under this idea that everything that passes through interstate commerce is theirs to regulate. Actually, to me, I think that's just kind of a fake cover to try and justify their illegal, unconstitutional, and, well, we'll call it tyrannical regulations and rules and laws. If you want to find out more, of course, head to the website, constitutionstudy.com. Find this article, follow my link, see if what I'm telling you is true. Read the decision in Filburn and see if someone who basically is raising wheat, yeah, he sells a little bit of that wheat in his own state. And he uses it to feed his cattle, his animals. And he uses it to feed his family. How is that interstate commerce? It could impact the price. That's not what interstate commerce is. So again, to me, this is the source of so much of Congress's fake power. Now, while you're there, I hope you'll consider, well, heading to the store, constitutionstudy.com/shop, and maybe buying a book or a t-shirt, or hey, just donating to the cause. Help me pay for all the work that we're doing here. And help me bring this word to more and more people. See, I love to speak in groups, wherever I can. And it's really nice if I don't have to charge them to go out and do it. I mean, a lot of people charge a speaking fee, and that can get rather expensive. I don't want to do that. I want to be able to go and speak without charging a fee, maybe just trying to recoup my travel and living expenses. But I can only do that if people like you support the work that we're doing here. There's a donations page on the shop where you can donate to the cause, either a one-time or recurring donation. And if you'd like me to come speak to your group or event, give me a call. Contact me through the website. I would love to give it a try. I love speaking in front of people, especially about these constitutional issues. But these are all great ways you can support me. Of course, you can also support me with your cell phone. Patriot Mobile is America's only Christian conservative wireless provider. They not only give you great service, 4G and 5G coverage across the nation, 100% US-based customer support, but they take a portion of every dollar to support organizations that are defending your rights, organizations like the Constitution Study. So you can support the work that we're doing here by going to patriotmobile.com/constitution and signing up for a plan. By the way, are you a veteran, a first responder, or are you just a family with multiple lines? You're all eligible for discounts, so you can save a little bit of money too. But only if you go to patriotmobile.com/constitution, find a plan and discount that works for you. And by the way, if you use the code Constitution at checkout, you'll get your line activated absolutely free. Great phone service, great customer support, and supporting people that are protecting your rights all in one package seems like a pretty good deal. Again, only if you go to patriotmobile.com/constitution, sign up for a plan, and don't forget to use that code Constitution at checkout for free activation. Most of all, I hope you share the work that we're doing here. Let other people know, and hey, maybe you'll come back next time and bring a friend when we get together for the Constitution Study.
Love your neighbors and have a few good friends.